So that's AKOSUA SERWAA.
Yes, SERWAA for Su. AKOSUA SERWAA for Su. That LUMBA.
And then ODO BRONI.
What application did she take to court?
So she brought an action for the court to adjudge and declare. So first, in order to assess the action, we have to assess what happened. So she was laboring under the impression that she was the only wife of Daddy LUMBA and consequently entitled to perform what we call the kuna. That is the widowhood rights in English. And so she, upon seeing the fact that...
she was believing that she's the only legitimate wife.
Legitimate wife.
But in terms of cohabiting, she was aware that ODO BRONI was cohabiting with Daddy LUMBA for many, many years.
Yes.
Which cohabitation produced offsprings.
Yes. But cohabiting in the face of civil marriage, obviously, is still cohabiting.
So I mean, in her mind, she was going to court to enforce her rights.
As a wife to perform...
As the only wife.
As the only wife to perform the kuna or the widowhood rights.
Was that not being antagonistic, or it doesn't matter in law?
Well, I mean, law is antagonistic in nature. The reason we sue is to fight.
Yeah.
And so if
but
they
that's
are
the point
fighting,
I'm making. Did she need to pick up this fight, given the circumstances?
I wouldn't really. Maybe it depends on what the widowhood rights means to her.
Okay.
I would have gone after the properties.
Was she being denied of performing those widowhood rights?
So you remember the first time we had this discussion?
Yes.
I was even suggesting that they should just sit down and talk, and both of them should do it, because there was a wedding, there was a funeral I attended at AKOSUA, where a similar thing happened, and both women did it. It's not really...
I get that, but I'm saying that ODO BRONI, given the circumstances of her legal action, was she feeling, was there any
that
suggestion that she would be denied widowhood
For
rights?
that I cannot.
Abusia Penny suggests that there should be no such suggestion because
that I cannot,
they had discussed it.
Yeah, in fact, after the writ was filed and the injunction was denied, the judge advised the parties actually to go home, sit down, and consider exactly.
But would it matter to a judge, or should it matter to a judge if the judge finds that this application is quite antagonistic? Should it matter to a judge? Can it influence something?
Well, the motive for the case is it's based on two things: fact and law. And so the motive behind it really we don't
discuss that.
We do not discuss the motive. But
so she went to court to tell the court that she's what?
That she's she as the legitimate wife, the sole legitimate wife per her perspective, is entitled to perform the kuna and be recognized as the sole surviving widow of Daddy LUMBA.
Okay. And who did she sue?
She sued three persons. So 2 persons, 1 entity, or 3 persons, as an artificial person is entitled to be a person in law. So one, she sued the Busia Penny of the royal Ekwana family of Pakoso and Nsuta. She sued the second, ODO BRONI, and then she sued Transitions.
The home where the body is being kept?
Yes, presumably. And the reason often they do that is because the person who holds the mortuary paper is the only person that can come and remove the body from the mortuary. So often we would sue and attach the mortuary, the mortuary home, to put them on notice that a pending court action is going on. And so if anybody comes with a mortuary paper, or you should think twice before you release the body.
Otherwise you fall foul of
contempt. You may fall foul of the law. Because you are more or less sidestepping or going ahead of the process.
So her lawyer was Kusi, whom I know well. Was ODO BRONI represented?
Yes, she was represented by Oseusu of Cardinal Law Group, formerly at Akufo-Addo Prempeh & Co.
Yes, I know Oseusu. And was Transitions represented?
Yes, they were represented, but I really could not identify the I wouldn't say I cannot identify, but I do not know. I don't have personal knowledge of. For Mr. Oseusu, I know. In fact, his son is also my friend.
Okay.
He attended St. Augustine's, was my junior at St. Augustine's. So for him, I know very well. He and his son, I know. But I do not know Council of Transition.
So when it happens like that, both lawyers will be asked by the courts to respond to the application? Is that what happens?
Yes, all of them. So you can elect the 3 defendants, the Busia Penny, ODO BRONI, and Transitions, could have elected to be represented by 1 counsel. They could also elect to pick individuals. The court's not going to force you. It is your individual right to pick who.
So will they all have to compulsorily respond to what Kusi has written?
Yeah, written as in the action when he filed it. Oh yes, because failure to do that means that the court would go on to hear the matter without you.
But in responding, at the time, Kusi says that AKOSUA SERWAA is the legitimate wife of LUMBA. You are a lawyer for the other side. You don't have any basis to challenge until and unless he brings the matter before the court and you see the documents? Or do they send the documents to you that based on these documents, this lawyer is saying that AKOSUA SERWAA was married, so can you please give us your response?
Most often than not, what some lawyers do is that they may write a letter or somebody tell me a demand notice that based on these set of facts, we do not know why you have said so and so is the widow. Consequently, you are given 7 days or you are given 14 days to rectify the issues, or we can have a meeting and discuss extensively. So that means that instead of going to court immediately, they can arrange and have a roundtable
But they
discussion.
didn't do that. I'm just trying to get
That's what they
viewers
did. So it
understand
is not compulsory.
for you to respond to the court.
It's compulsory for you to respond to a court summons. But you were saying
Response
that
means
before they
physically
went to
show
court,
up or write something.
you do what you call, you enter appearance.
Yes, and then after that,
So the entry of appearance is a form that tells the court and the other party that you intend to come into the matter and defend the action.
that this is a lawyer.
That this is a hand. So if you want,
Okay, so beyond that, should they respond to what Kusi is saying?
yes. So the entry of appearance is just telling the court that you intend to conduct the case. After you enter appearance, you do something called the filing of a statement of defense. So you file a statement of defense, which will set out all the specific terms.
But that's what I'm
upon
saying, that
which
this
you
is,
want to
this is a
respond.
matter in which somebody is saying, pleading that this person was married in Germany. You are the other lawyer. What do you think will be the documents they will send?
So what we'll do is that we'll say we'll put you to strict proof.
Okay.
Because at the pleading stage, that is when the writ is filed,
Yeah.
we do not take evidence.
Yeah.
We only take evidence at trial.
So you just respond and say, we'll put you to strict proof on
Of
this
same.
one.
So we
Okay.
we deny that averment.
Okay.
Defendant denies the averment and we shall place the plaintiff to strict proof of same.
Perfect. So that's what I wanted viewers to understand. I'm sure viewers are following and you get me. Okay, now let's get into the matter. Okay, so producer, now record from here. Okay, so she brought an application that she's the only wife. Then what did the court do?
So the trial, in fact, after the writ was filed, there was an application for an injunction to prevent the conduct or to prevent preparation towards the conduct of the funeral on the schedule to take place on the 7th of December.
At the time,
Same at the time. Same was denied by the courts.
the court denied the...
Denied the injunction. So the courts held that the funeral, sorry, I keep saying wedding.
Oh, is that where the judge said that she will finish quickly?
Yes.
Okay.
That to be expedited. I mean, with regards to the matters in retrospect, I mean, it's a funeral. We really don't want the body to be in mortuary for a while, and consequently, it was important that the things or the processes end early, so that the funeral can take place. However, it's not. I mean, maybe it's because of the public interest around this matter, but there are some cases where they fight over the corpse for 3 years, 4 years.
Fair enough. Let's move on quickly. So that injunction was denied. That means that those who are planning the funeral can go ahead to plan
Can
the
go
funeral.
ahead pending the determination of the
All right.
substantive act.
Then what happened? What
So
documents
after-
were presented?
So, Judge LUMBA, SERWAA presented an extract of a marriage certificate to prove, or a copy of a marriage certificate in Germany. I've forgotten the specific town. The marriage registry in Germany to prove that indeed they were married. She also, or her counsel, also presented before the court a video purporting to be, a picture purporting to be same that proves the conduct of the marriage or the contraction of the marriage in Germany. Now, this is where the issues get a bit technical. So, really, all the issues of law we discussed are the same. The position of the law has not changed regarding marriage. Anybody who contracts a marriage under ordinance, that marriage excludes everybody else. However, the question now is, are you able to prove that indeed you contracted a marriage under civil law? Or in Ghana, I would say under the ordinance. And that was the main bane of contention. In fact, the judgment was about 49 pages. That took a chunk of the judgment. And
As
it
to
would seem
the level of weight that will be put on the documents that have been presented.
exactly.
Okay.
So that what we call in law the probity value. So the lawyer Kusi presented an extract from a family book that in it states that indeed they were married. This was the marriage certificate. He also produced a copy purporting to be the copy of a marriage certificate. Notice that the court found that same copy was unsigned by the parties. That copy of the said marriage certificate was unsigned by the parties being AKOSUA SERWAA and Judge LUMBA. Further, the issue of a civil marriage contracted in Germany, if you look at Section 1, subsection 2 of the Evidence Act, it's a matter of fact that has to be proven. So let me break it down. In law, there are mainly two things that the courts looks into, or courts used to decide cases: law and facts. Now,
so let's break it down. So fact is, when Kofi Broni was crossing the road, the red car hit him in front of Sofo line at Prempeh College in Kumasi.
That is fact.
So that's fact.
That is fact.
The law is, where a driver hits somebody at the zebra crossing, he shall be so and so and so.
Exactly. So that's the
So
law.
you're now coming to put the facts into the law.
Yes.
To show that these facts, the law as prescribed, the occurrence has happened.
Yes.
That this guy did what the law prescribes in section so and so.
Yes.
So that's a fact and that's a law. Okay.
So another example may be murder is section 46 of Act 29. That is the law. It says any person who by unlawful harm causes the death of another person intentionally causes murder or can be found guilty of murder. That's the law. Now the fact is, I took this statue and hit your head with it. That's the fact. So now the court will look at the fact of me taking the statue and hitting your head and the law of section 46 and make a finding as to whether or not indeed that happened.
Okay. So the fact here is what? The certificate? The
fact here is the fact that, one, the process of contracting marriage in Germany now becomes an issue of facts. Because if it were Ghanaian law, you don't have to prove it. The judge is presumed to know what is in the Marriages Act. However, when it is a foreign law, it now becomes a matter of fact, which has to be proven. Meaning...
Okay, so foreign laws, whilst they are laws,
even
when they are adjudicated in a Ghanaian court or in another jurisdiction's court, they will be deemed to be facts which have to be proven.
Yes. So if you are saying that this law in Germany says that once I marry someone, that is a monogamous marriage. You can't just assume that the judge knows. In Ghana, you can say that if I marry under the ordinance,
it's
Ghanaian law, it's Ghanaian judge. The judge is presumed to know. But if you are saying that I married under German law, and under German law, this form of marriage is monogamous, you must prove it before the Ghanaian court.
How does he do that?
So you can call an academic from Germany, who is an expert witness, a lawyer. In fact, so there is one, what we're trying to do is we're trying to show in the UK that the purported marriage contracted by two persons in Ghana was not valid. So we had to do research, extensive research, annex it to a witness statement, have it certified and sent to the United Kingdom so that it will be pleaded in the United Kingdom, before the United Kingdom, the court in the United Kingdom, that we have gone to Ghana, we have spoken to lawyers so and so of this firm. Lawyers so and so of this firm have the capacity to speak to Ghanaian law, and they have told us that this and this and this is
so that's the expert witness.
That's an expert witness.
Okay. So Lakusi should have asked the court to bring an expert witness.
He should have made arrangements. So at a stage before the trial, we have something called application for directions. And then your pre-trial checklist, which you attach to your witness statement. The pre-trial checklist is what you are telling the court. You intend to call one or two witnesses. One or two witnesses will require translation you require someone to translate from English to Tree, would require an expert witness, all those things. Maybe, so ordinarily that was what ought to have been done. I cannot really speak to someone's work because maybe the value of what he also placed on things were different based on his...
No, I heard it. Something he said that based on the fact that I think it was the journalist called Ola who said it on UTV, that based on the fact that he had submitted the documents of the marriage and the fact that ODO BRONI in cross-examination had accepted that she was aware that Daddy Lumba had been married in Germany, that the combination of the two facts should have led the judge to conclude that the certificates were valid.
And that is why there's also so that's an admission in that respect may give rise to the fact or the recognition of the fact that they may have been married in Germany. It does not give rise to the blessing of the authenticity of the certificates. Because although BRONI may have admitted that, well, she knows they are married in Germany, it does not necessarily mean that the marriage certificate provided or produced was valid.
You need at the same time process to prove that.
Yes, you can never assume. Now, at the same time also, it may be grounds for the Court of Appeal to look at if they decide to go on appeal. Because that may mean that the fact of marriage was established. The fact of marriage was established.
What kind of marriage it was?
That is the question. So that's exactly what I was coming to.
But the judge has answered
because
that question.
The fact of marriage that they were married is true.
Although Broni is
But
not disputing that.
is it monogamous?
Yeah.
And is it being monogamous that had to be proven before a Ghanaian court?
And that's what they couldn't do.
Yes.
Simply, did the judge say in her ruling that it is because you did not lead evidence to prove this fact?
The judge actually expressly mentioned that they could have got a lawyer from Germany or an expert witness or an academician, a legal
So
scholar.
the judge faulted them on the
That's what there are other
on
grounds.
the procedural deficit.
Yes, it's not substance. As I said,
okay.
that the position of the law still hasn't changed. Once an individual marries under civil
So
law,
they were not able to establish.
it was
that.
an issue of proof. That's all. That was the whole. It was proof.
Okay.
Failure to
So they
prove.
couldn't prove it.
That was it. There were also some issues of the fact that the document, being a German document, had to be authenticated by the Ghanaian embassy, in Germany. Because when you are providing an official document in Ghana, a Ghanaian official document, there is really no need for you to have it authenticated. Often you go to Commissioner for Oath. They are around Accra, Arena, and that side, right? But when you are bringing a document from outside to prevent fraud and counterfeiting, what we often require, more particularly per the Evidence Act, is that you send it to the Ghanaian consul in that country for them to certify the signature on that document before it is brought to Ghana.
That
and
wasn't
used.
done.
That also was not
And
done.
the judge drew attention to that.
And the judge also drew attention to the fact that that wasn't done. So there was no means of authentication. They could not authenticate the said document. Apparently, when they applied for the injunction, the courts, the judge, drew the attention of the plaintiff to that these documents you intend to rely on for the grant of the injunction, you have to look at it again because these are the issues. And so, in fact, the lawyer the judge noted it that the lawyer for the plaintiff mentioned that, okay, he would go back and put his house in order. But it seems he may not have had enough time to do so before the trial.
Okay. So that ends the court one. Let's move on to another segment now. So now let's talk about the social issues that have paraded this matter. So as of now, the judge didn't say the date of the funeral.
No. The judge, it's not the judge who determines the date of the funeral.
But there's a date 13 December.
So just that, often what we call is the maintenance of status quo. It simply means that the way things are,
Keep it like that.
keep it like that. So the way things are now, Ebusua Penny says is December. So keep it like that. Keeping it like that means...
Papa, she says it's not December.
So that's the fight. That one is not the court's business.
I like Ebusua Penny. You know, what I like about him is his calm demeanor. And you know, Papa Shi and the other people have been trying hard to say that Ebusua Penny was not that close to Daddy LUMBA. Ebusua Penny actually admits it. That he doesn't know where he lived in Tantra Hill.
Oh, yeah.
Doesn't know where he lived. He comes to his house once in every 2-3 years.
Yeah.
That he's going to his farm and they sit there and converse with him. He doesn't know anything about him.
I don't even know my Ebusua Penny.
So because he's admitted that and said that he's just in to play a role,
yes,
it gives him a bit of credibility, you know, as opposed to the...
Even initially, I don't know if you remember, but the Ebusua Penny said he doesn't even know who ODO BRONI is.
Oh,
as
at
a
the
wife.
beginning?
Oh yeah, initially.
Oh, I see.
Oh,
But he led evidence in court apparently to say that he was told about ODO BRONI's marriage. And those who were ridiculing him said that when he was asked about the person who told him, he cited 3 people, all of whom have died.
Yes, and
So
that's
he says, Mama Mansa something told me. She was an important person. The Ebusua Penny that he inherited also told him, but they have all died.
Yeah,
But that is how he got to know that ODO BRONI was married.
and that speaks to hearsay.
Yes.
That's why I said that. These are the issues that may come up. It's quite
So as it is now, we are headed for a 13 December funeral because government is involved. I think O2 Force people are involved.
ordinarily to be 13th. So the remedy now is they could apply to the Court of Appeal. Sorry, they could appeal to the Court of Appeal with the judgment and the record, telling the Court of Appeal to take a second look at the judgment. The only issue is in appeal, what we do is you just transmit the record and you send it up. You can only add by proving exceptional circumstances that maybe this piece of evidence was not available at the time
Yeah.
this matter was at the High Court. Therefore, please have a look at it, or let me add it to the record. And then upon doing that, they may also apply at the Court of Appeal. They can repeat and try to maybe halt the performance or the organization of the funeral. There's an example of one of the, oh, it seems it's not loading. I picked a portion of the judgments, more particularly the technical parts. The English, and in fact, the reason we didn't even put it up was it was very technical. So many of the things would not really resonate to the normal. A lot of people have not been able to understand.
Let's go back to the photographs.
So, therefore, an extract cannot be approved. They should have
So what's an
attempted-
extract though? Photographs.
Photographs, please. So the extract here was an extract from a family book purported to contain, it was a sort of family record.
Somebody said that's what they do in Germany. It's okay, that's fine. I want to show us that extract.
No, I wanted to expand there are white borders around.
Yeah. Okay.
Well, we deal with what we do in Ghana. So the procedure is Ghanaian law.
But they said in Germany, that's what it is. So these are some of the things somebody from Germany should have come to say.
So it's all about testimony.
Yeah.
It's all about testimony. And it's not as if it's something that is not done. It is done. And I'll give the example of one that has been done that I know that someone has done.
You know, there's this talk about AKOSUA SERWAA saying at some point that she doesn't want to have the relationship with LUMBA anymore. And she wrote a letter, LUMBA ignored it, and apparently it was read in court. What's the value of that?
So in fact, I put it as one of the themes for discussion.
Okay.
But we couldn't go there. So the court found that there's an extensive process for the dissolution of customary marriages. The court found out that yes, Daddy LUMBA and AKOSUA SERWAA were indeed married under customary law. And then maybe subsequently, AKOSUA SERWAA says or makes the point that the marriage was converted to civil in Germany. So the court now says, or the court made the point that there's an extensive process through which an individual can claim to have his or her customary marriage dissolved. That process was not undertaken in this case, and therefore,
But the fact that she wrote a letter
is not sufficient to
but the
dissolve the
letter
marriage.
begins the process, doesn't it?
Well, the court laid down these steps. That one, there has to be communication. There has to be a meeting by both families of both AKOSUA SERWAA and Daddy LUMBA. The reason being that under customary law, it's not just a marriage between two persons, but a marriage between their families. So there has to be a marriage. It's a prerequisite. It must happen. Now, the parties have to be called and interviewed by the family members as to what are the specific reasons for which they wish the marriage to be dissolved. 3, they must then have a mediation session
So those
or
steps,
attempt at mediation.
those steps were not done.
Those steps were not undertaken. It was just the writing of the letter, the purported writing of that letter, and the purported returning of the drinks, which they claim was sufficient to dissolve the marriage, the customary marriage. But under customary law,
Okay, so that was being urged by BRONI's lawyers.
yes, in
That
fact,
in fact, AKOSUA SERWAA had cancelled the marriage.
the marriage. In fact, that was even more so by the Busuapeni's lawyers. I think one Fatima Yila.
So the court rejected that.
The court rejected and found that AKOSUA SERWAA is still married to Daddy LUMBA under customary law. I don't see why they had to go into that province, the issues of abandonment and issues of marriage and the customary law and all that. I don't see why they even went there anyway.
It
Because
doesn't
the
have any
crux of
legal
the
legs.
matter,
The fact that AKOSUA SERWAA has not seen LUMBA for a while doesn't have any legs in court.
it doesn't.
Really?
Once you are married, you are married. The process for dissolving marriage is there. Undertake those processes.
Well, is
you
that
can
not
use.
is that not a legal maxim principle that after 7 years of no interaction?
No, that is after 7 years is when that's in the Evidence Act section 33. That's after 7 years of not hearing from the person at all, and all attempts to reach the person have proven futile. Then you can, if the person is presumed dead. So remember Castro.
Yeah.
So when the person is presumed dead, and so that is when.
So to the
in
extent
effect,
that LUMBA, you can lead evidence to show that LUMBA was hearing of her
and knew she was alive, then it's
and
not.
knew that she was alive,
However,
through the children and all that.
there is desertion. There are 2 forms of desertion in the Matrimonial Causes Act: desertion for 2 years and desertion for 5 years. In both of these instances, they assist the courts to come at the conclusion of dissolving the marriage the desertion in and of itself is not the dissolution of the marriage.
Oh, so it's like a weight of evidence.
So the court will say, okay, because you haven't stayed together for 5 years, I am hereby cancelling this marriage. But you can't say that because they have not stayed together for 5 years, automatically the marriage is dissolved.
So there's nothing that automatically dissolves a marriage except death.
Except death.
Yeah.
That will automatically dissolve a marriage. Or somebody vanishing for 7 years, you do not hear from him at all. No trace, like something like Castro as an example. So Castro's thing, after the 7th year, they did something in court to mark that indeed now he's deemed to have died. The person gets missing for 7 years. And it happened a lot in those days. In those days, there was no social media, there was no phone. You jump the under of a ship. You remember, I don't know if you watched that movie, Deadly Voyage.
Yeah, Deadly Voyage, yeah.
From Takoradi, Sekondi.
You are going to
Liverpool. You don't hear any, there are some people who don't make it, some people die in the Sahara Desert. So for 7 years, if you do not hear in such circumstances, you can go on and marry another person. But abandonment in and of itself, or failure to live together as man and wife, is not in and of itself divorce. It can help you get a divorce. So
it's dangerous for people to act divorced, but enjoy their separate lives. It's dangerous.
What is it, act divorced?
So they've separated, the woman has moved away, lives in another house, the man lives in another place.
Yes,
they're effectively divorced, but they haven't gone to court to say anything.
Yes, it's
dangerous.
So even, it's dangerous because even under customary law, and that's what I said, that the court laid down the steps, that even under customary law, these are the things that are supposed to be done. And I remember the head of chambers, when this issue came up, Mr. Alex Quinn, who was a former board chair for Land Commission, told me a similar story that happened in Bono. He said many people think that the mere returning of the drinks is divorce. And that when he went, his grand aunt told him that no, and that the extensive processes that have to be undertaken. So the mere fact that you have fought with your wife and you take the customary drinks back, your wife takes the customary drinks and comes to give it to your mother, does not mean you have divorced. Because in fact, even the person who who receives the customary drinks is also important. It's not merely going to the family house and seeing playing football. You drop the customary drinks and say, "Me the main saba," then you are done. Means I've brought my drinks, so you are done with the marriage. No, it does not. It's not like that.
Even when somebody has expressed her intention, Lumba, I don't want to marry you anymore.
Yeah, so follow through the process. When the law lays down the process.
But she didn't follow through. It means that she changed her mind?
Yes, and you see, the rationale is, marriage is such that I don't know, I have no experience it, but I'm sure that those who are married will. I mean, you fight, you make up, it's like friendship. So if we allow it to be dissolved easily by any mere interaction or altercation between persons, then it will be a problem. There are people who have had long marriages who maybe for a period of 2 or 3 years were not speaking with their spouses because of one or two things.
Somebody said I should ask you this. If Lumba had married Auto Broni under ordinance, what would have happened?
So, if Lumba was married to AKOSUA SERWAA under traditional, under customary, assuming, I'm not no disrespect to her, assuming under customary law, he still could not have married Auto Broni under ordinance. Because in Ghana, all the 3 forms of marriages we recognize, whether ordinance, whether Islamic, or whether custom, is
so
deemed
Lumba
to have
would
the
have
same
already
value.
been married.
He would have already been married.
Can only marry Auto Broni under
customary law.
But not under ordinance.
Yes.
I see.
So he could not have crossed to marry someone under ordinance.
So that marriage would have been invalid?
Yes.
Would the court would have had the power to convert that marriage to customary?
No, the court cannot convert marriages.
Oh, I see.
Only the parties, because it's a contract. So the parties are the ones who would decide. So the court cannot compel, and moreover, you cannot grant blessing to an illegal act. So once it's illegal and it's bigamy, it's an offense, then the court cannot convert it because it's void ab initio. Void ab initio means void from the start.
There's a moral concern. There's a moral concern from people that the success of Auto Broni will make it look like it is carrying impetus propensity value. That means many more people want to go into Daddy Lumba's abode. They say she went there as a house help. If that is true, I don't know. Go to Daddy Lumba's abode, entertain him, procure with him, and be able to now find legitimacy when the man, a huge famous man, dies. So Auto Broni's success is undermining the moral fiber of our society.
It happens a lot. In fact, this was one argument I had with my lecturer in equity. Dr. Amma Hammond at the law faculty. And she made this point in this case, Asha and Daku, where a similar issue, but the court held that the property a man had bought in her name did not belong to her because the man was managing the property and so she was holding it in trust for the man. And then Dr. Amma Hammond made the point that she believes that the reason the court made that determination was merely because the woman was a paramour or a side chick. So she was I don't want to use some language, but she was a side chick of the man. And that's why the court refused to recognize that she's the owner of the
and then
property.
your lecturer was concerned that these so-called side chicks are not treated well. Is that the point?
I won't say it's like that, but you know, it is a moral view of society. But the thing is that we also have to decouple morality, or in many senses, morality is decoupled from law. There are many judges who are Catholic yet dissolve marriages. There are many judges who do things that may affect their personal. In fact, I was in court one time and someone came and they applied for surrogacy. And the judge gave. But assuming the judge was a Catholic judge who does not believe in surrogacy, he still has to. So the thing is that, as former Chief Justice Tokonu will say, no matter the noise you make, the law is the law. So in this instance, I don't think the issue spoke to merit or substance. It was procedure and technicalities. I noticed someone made
Although BRONI's victory should not worry people, the moral...
Yes, it should just be a call for people to do the right thing and maybe to be more meticulous. And I now understand why when you ask my mother for my school reports in KG, she still has it hidden somewhere. So you keep all your papers. Some people, it gets to a point in time, even to prove their marriage is a problem because their marriage certificates are missing. So we have to go to AMA and write. Some of them, maybe their churches were not the big churches, so they did not issue the certificates to them. Some got a certificate, but the venue was not registered.
I see.
Oh, yes.
And they think they are married.
And they think that we are not married.
Under
the
law.
Venue, even the place where you marry, the place where you marry is important. So I cannot speak for other churches, but for the Catholic Church, they will say, come to the church and get married and let your certificates be issued. So the priest will sign the certificate, you will sign, and normally your best man will take it and show it to everybody. Because once it is declared a parish, the state gives the priest the authority to issue the certificate. So many people, they've gone to do these garden weddings at event centers, but they are not married because the venue of the place. So if you are like that, you have to go and check. The place has not been earmarked by the law to be a place where marriage is. Even time. The law prescribes time. You can't marry in the night. Yes, for marriage.
What time do you have to marry?
It gives in the day, within, I forgot the specific hours.
From 8 to 4.
It gives a period of time to marry.
Oh, but those who want to say I do under the moonlight.
Or better, so you can go and do AMA. Many people do that. So they go to AMA, they do the proper one. Then the rest is the blessing, whatever you do. So you can go and get a pastor. That one you are free. But for the AMA, if you do not attend maybe Methodist, Presby, Anglican, Catholic, to be sure, just go to AMA or confer from your pastor. Even that one, I remember about 3 years ago, a pastor was arrested for giving certificates when he does not have the power to do so.
Oh, I see.
So that one, so you have to be careful. But many people to play
So
safe,
those who want to travel,
AMA.
for instance, and prove Ghanaian marriages abroad, they should be really careful.
Yes.
They should have a lawyer with them.
Experts to show that this is the marriage. These are the incidents of the marriage. And this, because the courts abroad, I can speak for the UK because I've studied their legal system, so I know. I don't know for other legal systems are a bit lax. But the UK was the one that I have worked on, so I know for a fact that for there also, foreign law is a matter of fact. That also has to be proven in the courts of the UK. Yeah. So there was an instance where a woman applied for LA, got its letters of administration to administer her husband's estate, and then she just procured affidavits of certain people to say that they were married under customary law. And it was an issue because by so doing, it shows that there was no way the courts could have an assessment of what customary law is because there was no expert to speak to what customary law is. So they had to go and get a Bushapini in the family, in the village, to swear and state these are the reasons before you go.
Thank you. Thank you very much.